Welcome to the Asigo and Mukami show,
where we keep it fierce, focused, and fabulous.
My name is Asigo.
And my name is Mukami.
If you're new here, kindly subscribe to our channel, hit the notification bell, and don't forget to leave a comment.
We have a wonderful topic prepared for you guys today. We are talking about wealth planning. What next after you have acquired and consolidated your wealth? What happens after you die? Uncomfortable questions, but we are here to help you through it. Once again, we are joined by brilliance, strength, and beauty. Two legal practitioners with vast experience in this field. We will be right back
after the break.
Asigo and Mukami.
Welcome back to the show. Today we have Eunice Kavere and Paulette Achieng, partners at Lumalas Achieng and Kavere Advocates. Our first guest is Eunice Kavere. She has been an advocate of the High Court of Kenya since 2006. She is a certified company secretary, a certified public accountant, and an MBA graduate. Her major practice areas include transaction advisory, intellectual property, and corporate governance.
Thank you so much. I'm happy to be here.
And the second guest of the day is Paulette Achieng. Paulette has more than 15 years experience in conveyancing, real estate, and banking practice. Paulette is also very passionate about family law. Welcome, Paulette, to the show.
Thank you so much, Asigo and Mukami.
My first question would be, why preserve wealth?
I mean, your wealth that you have accumulated over all the years that you have been alive is the sweat of your brow. And it's only natural that you have a say in what happens to it in the event that you're no longer alive. We have unique circumstances in each of our lives, and therefore the reason why we plan our wealth is different from person to person. We have persons who have no spouses, no children. We have persons who have children out of wedlock. We have persons in polygamous marriage settings. We have separated spouses, divorced spouses. And I can say that there's also the need to disclose to your beneficiaries or your loved ones what are these assets that you have acquired over all these years, so that you have a say in what goes to whom. I think that is the key reason why we plan our wealth.
That's very interesting, Eunice. I think for me, my question would be, at what point do you start planning to preserve? At what point do you start planning for death?
There really isn't a set time when you should start planning for your wealth, but the fact is that death is imminent, and a prominent writer said death doesn't come a day closer just because you have started writing. So I would advise anyone with the first asset, start planning and thinking about it, because like Kavere said, it's the sweat of your brow. So you don't want it to waste away, and you start planning as you acquire, even for seamless consolidation of the assets.
So Mukami, it looks like what they're trying to say is like we need to have a will. Do you have one?
I don't have a lot of property. but I don't know, on the same issue of wills, I don't know, is it a verbal will, is it a written will, I don't know. Because kama ni verbal, I have already dished out my...
No, but I thought that a will doesn't really involve property and whatnot. Like, you have kids, so maybe you can say, I want my kid to be with so and so.
I don't know. I would like to hear that from them, because I think when a child has two parents, I think the child goes to the other parents. But let's hear what they have to say.
Asigo, you're right that what we seem to be suggesting is that you need to have a will in place. That is true, but a will is not the only tool that is available for you to plan your wealth. And perhaps as we progress this conversation, you can give us opportunity to tell you what other tools there are that can assist you to plan your wealth.
I also had Mukami say that wills can be oral or verbal. She was given verbal instructions, but for the purposes of the law, maybe we just need to point out that while you can have a verbal will, it can only be it can only be valid if it's in existence for less than 3 months within which you have died. So it would be better to have a written will that can outlive the 3 months, because as we said, you don't want to keep on repeating your instructions every 3 months. So that's just something that needs to be noted. Yes, you can have a verbal and an oral will. There are very many forms of wills that you can have within the confines of the law. Even a living will, if you feel that you're unwell and you want to leave instructions on what should happen in the event that probably you get into a coma, you can do a living will to give instructions on what should happen to you in the event that you become unwell.
So, Kavere, before we continue, kindly define what a will is for the sake of that viewer who doesn't know what it means.
A will is a very simple document that you prepare with the help of your lawyer, and what you're writing in that will is a set of instructions that are saying, what property do I have, and once I die, who should inherit that property. That is what a will does. And it goes further to appoint someone who is going to carry out those instructions on your behalf. We call that person an executor, and you want to choose someone that you trust, someone that you know you can leave your affairs with, and they will implement your instructions to the letter.
Aside from property, a will can also be used to carry out certain instructions. For example, if you have a specific ritual that you want upon your death, for example, if you want to be cremated as opposed to be buried, or if you want to be buried in a certain place, if you have children as well, who will be the guardian of those minor children, and there are other things that you can indicate in your will. It is not just about property, as some may believe, but since we are talking about wealth planning, yes, that's one of the major issues that it handles well.
My question at this point would be, how binding is the will? Because I feel like I can come to you today, tell you the property I have, and being individuals, we are always looking out for ourselves. And then you might probably go ahead and just inherit, especially us who don't share properties that we have. And then suddenly I'm gone, and you have the list to all my property, and probably even the person who I left as the executor is probably MIA, or is missing, or is also dead, or like how can you guarantee us that once I put up a will with you, it will be safe, my property will be safe?
So to answer your question, Mukami, that's a very good question, because if you remember where we started, we said there are different types of wills. So each type of will has its requirements, and that's why, for example, to preserve your assets, it would be difficult. It would be foolhardy to have an oral will, because then who knows what are the assets? I mean, it's not recorded anywhere. So, but even then, there are special circumstances where written wills are acceptable, and also there are other requirements. For example, there has to be witnesses, and not less than 2 witnesses at that. So those are some of the safeguards that make it difficult for a person to take over your will. Another issue that you raise that I feel is important to point out is, even as you change the properties, you can easily revoke your will and indicate other properties. And in the event that you marry or you get remarried, there's a requirement that then you write a fresh will. And all those are part of the safeguards that will make your will what you're calling watertight, so that not only one person it's not someone's word against the other. You are saying point this out to this other person, point this out to this other person. But in the event that nobody else knows and it is not documented, what happens? It will be a fight between those people. But when it's documented and there are witnesses and it's been reduced into writing, you're in a better off position than not having anything. Then your assets would get lost. So the point is, for your will to be valid, it has to meet the requirements of the laws. There are several requirements as to the capacity. That means, are you sane enough to write the will? What age are you? Are you of legal age to make even financial decisions and sign contracts? What form is the will taking? And other requirements such as witnesses. Is it done in the presence of witnesses?
Between recording a will, like doing a video, and writing down a will, which one is more important, or which one holds more weight?
There's no superior or inferior will. A will is a will, provided that it meets the requirements that Paulette has just told us about. So if you want to put on video the whole process of you putting your will down and having your witnesses present, by all means go and do that, but it is not a legal requirement.
Okay, thank you so much. I find this discussion very sober, and it is frightening because some of us think that once you do a will, death is knocking on your door, but it's good to learn these things when you're young. I think in the beginning you mentioned a few ways of wealth preservation, but we seem to be focused on the will, so I'd like to put it back out there. What are the other forms of preservation that we need to know?
Yes, there are so many tools that are available to us to plan our wealth and to preserve it. But this conversation is in a family setup, and therefore I would talk about family trusts. So a trust is a person, just like a company or yourself. So when you set up a trust, you're transferring property from yourself to another entity. How does this help you to plan your wealth? So when you die, if you have a will, then the court has instructions on what should happen to your property or to your children who are under the age of 18. When you have already transferred your property to a trust, all that property is not available for discussion because it is no longer your property. So you see, you have completely protected your assets from court processes, from people who want to come and tell the court that I was not provided for sufficiently under the will. So we use the trust instrument for that purpose. So what is a trust? I've told you that a trust is a person, but how is it set up? So under a trust, you have yourself as the owner of the property, and we call you a settler. And then we have your trust estate, which is every property, whether they are shares or land that you own. And then you have persons called trustees. These are persons or a person that you have appointed to manage that estate. And then you have a third element, which is the beneficiaries. And these are persons that you want to benefit from that estate. So if you put a trust and a will side to side, a will simply says, this is my property. When I die, I want so and so and so and so to get this and that. But under a trust, you have already divested this property from yourself to a third party, and you're saying, when I die, or even as I am still alive, because we have living trusts, then I want these assets to be managed by this person for the benefit of this person or these persons.
In addition to trusts, even the way we acquire wealth has an effect on our estates, because a lot of people, when they're buying jointly with someone else, they tend to put the names jointly, and not understanding that I can own a share of a property, which we call shares in common, as opposed to holding the property jointly. Why is this important? The way you hold it, if you're holding it jointly, then automatically, upon your death, it will vest in the other person. So for example, Mukami and Asigo, if you decide to buy property together, you may want your share to go to your family, but because it is joint, upon your death, we will just present the death certificate and it goes to Asigo. So a lot of people confuse the fact that there's joint survivorship. So even if you create a will, you need to know how you hold the property matters.
What Paulette has said about next of kins and the banks and the circles waiting for the grant of letters of administration, there are instances where people will die without a will. So you need to know this so that you understand why it is important to have that will in place. Suppose you're a man and you're married and you have children. When you die, your wife inherits a life interest in your estate. What do I mean by this? Suppose whatever your estate is, say the house you are living in when you are married, when you're still alive, then your wife has the right to continue living in that house or collecting rent and availing to herself the benefits from that property without a right to sell that property. And I'm saying this, I don't want to get too technical, but I'm saying this in the event that the title was in the man's name. It was not a jointly held property, because if it was a jointly held property, then it automatically vests in the wife. So my example is the title is in the name of the person who has died. So if he had a wife and children, the wife inherits a life interest in the estate, and the children are the ones who inherit the beneficial ownership. And they inherit this in equal shares. It doesn't matter whether some of those children were born in the marriage or outside the marriage or were adopted. All your children are equal before the law and they will inherit equally. Another scenario is if you had no spouse but you had children, then the children will automatically inherit your estate in equal shares. Let's suppose that you had no spouse and you had no children. Yeah, your relatives will inherit your estate in the order of biological closeness to you. So your father and your mother are nearer you than your brother and sister.
So it's interesting, Kaveri, even as you talk about the degrees of relationship, when you were talking about adopted children, that's another question I get all the time about what is the difference between guardianship and adoption, and if I have an adopted child, will they inherit my property? What about my other children? So if I take my sister's child, for example, and I live with them and I take them to be like my children, unless I take the legal process of adopting them, then they are not really an inheritor per se. They don't become a dependent. And yet the intention would be, as I'm taking this child, that she should be like all my other children. The difference between adoption and guardianship is when you're just a guardian, your word does not become an inheritor. You're just taking care of the child, and they don't have rights in succession. So it's an important conversation, even as you're taking care of the children, that you want to take care, even if they're not your children, but you want them to get something. And this is why we even talk about wills and what we are leaving to whom, because then if you don't have a will, like Kaveri said, the rules of intestacy come into place, and some of the people that you would love to inherit you will be disinherited.
That's very interesting, because we're reading a verse in the Bible, and it says that God takes us as his adopted children, and you cannot disinherit adopted children.
It's interesting that you mentioned that, because that's the position the law has taken. For adopted children, they're treated as your biological children for the purposes of succession. But if it's a guardian, if you've just taken on guardianship, if it's just a word, then they will not inherit you, so to speak.
That was a very, very intense discussion on succession, and as I hear it, that's just the tip of the iceberg. So, what's your greatest take home?
That's yani, in these relationships or marriage of ours, we just need to sit down and talk and just keep it real. Because, I mean, we just talk about let's buy this, let's do this, but we never talk about what happens if we die. So that's something I think tonight I have to bring it up.
Don't go buying to shambas with chama huko and then hiding and not saying.
It's not even fair, because you see when you die,
nobody knows what
nobody
happens.
knows anything.
I think for me, the other thing that I've learned is setting up trust. Because when you set up a trust, I didn't know that once you set it up, the property no longer belongs to you. It belongs to whomever is your beneficiary. So I think it's time that we set up. These things, we only see them in movies. America, you know.
What we see here is people fighting for properties
after people have showed up after
happens
you've died,
next.
you know. So I think when you set up that trust, your kids can be able to comfortably inherit what belongs to them without stress. And if others show up,
Pole.
kesi bada.
True.
So I think it's all about honesty. Honesty, what else?
Just honesty and trust. Trust and honesty. Zinapambana hivi.
Zinapelekana hivi. I think it's very enlightening to have these brilliant minds share with us, and I'm sure we'll keep the conversation going. Because for me now it just opened a lot of things that I want to know, you know.
Yeah, and if you don't know what to do, tafuta wakili.
Yes.
Yeah. If you need numbers, feel free to inbox us. We're gonna share.
Thank you so much. Kindly keep subscribing to our channel. Follow us on our social media pages, Instagram, Facebook, and Twitter. The Asigo and Mukami Show. Do not forget to press the notification button down below.
Keep it fierce, focused, and fabulous. Till next time. Bye-bye.
Asigo and Mukami.